Okay, I'm going to end the poll now. So now I would like to introduce the wonderful Joshua Lennon. Joshua is our lawyer in residence at Clio, an attorney admitted to the New York bar. Joshua brings legal scholarship to conversations happening both within Clio and with its customers. Trained in international and comparative laws and a graduate of the Brussels Seminar, Joshua has worked extensively to educate lawyers on technology's capability to enhance their practice, whilst also teaching tech companies about the unique needs of the legal system. Joshua, welcome and thank you for joining us this morning.
Oh, thank you,
Good morning,
Jillian.
your time.
Good morning. It's very nice to be here. I'm joining you all from Vancouver, Canada. So it is quite early my time. So I have my tea in hand. I'm very much looking forward to speaking with our panel, who I would like to introduce now. First of which we have Sophie Barrett-Brown, the senior partner and head of UK practice for Laura Devine Immigration. Sophie is a senior partner at the leading boutique firm Laura Devine Immigration and is recognized as a foremost expert in UK immigration, which is something I think that's going to be a very hot topic right now. She focuses on nationality and EU free movement. Sophie's clients are from all sectors and range from multinational corporations and entrepreneurs, high net worth individuals and families. Sophie is widely regarded for her work in influencing policy and sharing knowledge for the wider profession and migrant groups. She is trustee and former chair of the Immigration Law Practitioners Association, a member of Lexis's editorial consulting board for it's practical law, isn't it, Sophie?
Lexis PSL.
PSL, my apologies, and a regular conference speaker on immigration issues. Next is León Fernando del Canto, the head of chambers for Del Canto Chambers. He is a tax qualified English barrister and Spanish abogado. He is instructed regularly by solicitors and auditors all around the world. He's trained with KPMG, Deloitte, and Grant Thornton before moving into private practice. In 2006, he became the first Spanish citizen to hold double qualifications as a barrister in England and a Spanish abogado, and he joined the Honorable Society of Lincoln's Inn in London. He's a member of the Worshipful Association of Tax Advisors in the City of London, a livery company man of the City of London. It's a really impressive list there, Fernando. I'm really glad you could join us. And last but not least is Peter Wright, the Managing Director of Digital Law. Peter is a solicitor and leading expert in data protection. I rely upon his expertise. He also covers cybersecurity regulation and social media law. As Managing Director of Digital Law, he advises clients across the US, Europe, the Middle East, and Asia. He is the chair of the Law Society's GDPR working group, and we've all relied upon that work that you've done, Peter. Thank you. And the Policy and Regulatory Affairs Committee. He's a member of the Law Society board as well. He's also the author of the Law Society Cybersecurity Toolkit and a friend of Clio. So thank you all for joining us today. We have kind of two areas that we'd like to focus upon. First is general questions that I'd like to put to the panel, and then some specific questions where we really dive into each of your areas of expertise. So let's begin with our general questions, things that we think the audience might really need to know. So we're now 28 days into the end of the transition period, officially leaving the European Union. What, if anything, has changed for you in terms of how your business operates, and what changes are you still working towards? Sophie, I'd like to start with you, please. Oh, Sophie, you're on mute.
That's the rookie error there, isn't it, really?
It happens to us all.
I think the other panelists will probably touch on many of the themes that are common to our practices. So I think I'd probably look at that more from the nature of my practice as an immigration practice.
Please.
And this will sort of tie into some of the comments I'll probably make later on as well, which is to do with the effects that it has on how we're practicing with our clients and the key changes that are happening as a result of the end of the transition period. And obviously as an immigration practice, that's to do with talent and free movement of people, which has now come to an end. So from the 31st of December 2020, free movement has ended, and we are in the grace period now. So we have a whole cohort of people who were here before the end of the transition period and remain here, and new arrivals coming in. So, and we'll sort of touch on the detail of what that means a little bit later, I think, but it's managing those issues for clients, for expectations, how to deal with those different groups of employees and the various deadlines that are looming that they will need to comply with, but also potential access to a new pool of talent, which comes with some of the changes that are happening as a result. And again, I'm going to pick up on some of the threads of the detail of that a bit later anyway.
Yeah. Peter, it's a very busy time for data protection lawyers. What is changing for you in terms of how you operate currently?
I think the main thing we're having to be mindful of is just the fact that things are not quite the same as they were. Everything down to the fact that even now when we're invoicing our European clients, my area of expertise is data protection, not tax. I'm sure we'll be hearing a lot of that from Fernando, but I am a bit sort of double checking and treble checking when it comes to, what tax should we or shouldn't we not be applying to this. So you always want to make sure that you're absolutely fundamentally right on that. But also I think we are having to sort of really be mindful of the fact that I think a lot of the implications with regards to to Brexit and the deal that's been agreed, all the press coverage running up to it was all about lorries at Dover and lots of issues with regards to containers or even physical exports. I think there was a survey the Law Society did in the run-up to Christmas where I think it's like 3/4 of firms said, yeah, we're ready for Brexit, nothing for us to worry about. And I was quite worried that a large part of that was firms thinking, well, we aren't exporting, containers full of widgets through Dover, it's not going to be a problem for us. But as we're now seeing, there are significant consequences for the delivery of professional services. There are big consequences when it comes to financial services, and I think we are seeing those consequences already. And it's going to be an evolving relationship. We've got the EU looking at agreeing a memorandum of understanding with regards to further steps with regards to city and financial regulation.
Peter, I think we're having a little bit of audio issues with you. I'm sorry, could you repeat that?
I was just saying that we've got an evolving relationship here. So we've also got the EU is going to be agreeing a memorandum of understanding with the city and with regards to financial services and that may have an impact there on professional services. And there's also going to be more in the way of bilateral relationships going forward. So I think we're very much at the start of a sort of ongoing structure and a change in that relationship over the course of many years. It's not a standstill. And I think it's just making sure that our clients are aware of the fact this is a far more agile, dynamic relationship than it was in the past, and it will continue to change and evolve over time. So we can't sort of think, oh, this is something that's all okay. We will continually have to check as different changes come in with regards to this evolving relationship.
That's very much so. It's not the beginning of the end, it's the end of the beginning. And there's a lot more looking forward that we'll need to deal with as a consequence of this exit from the European Union. So Fernando, Peter actually raised some very interesting points, double and triple checking everything that he's doing with the continent. You actually look at this from both sides, with offices in Spain and offices in the UK. How are you handling both sides of this transition? Well, it's not, transition's not even the right word anymore. Both sides of this new environment. Yeah.
Not anymore, and in some aspects, yes, transition. And I think one of the uncertainties we are facing is that there is a lot to be developed, a lot to be talked about, but definitively from 1st of January, there has been a big change. And I'm going to put you an example. I mean, before going to the impact in our practice, let's see what happened to clients. I mean, our UK clients on 1st of January, a group of UK people were banned to travel to Spain. They were stopped in Heathrow Airport. We have been listening about Brexit for months, for years, and we were not prepared. So issues started arising from the 1st of January, the tracks that Peter's mentioning, immigration issues. So basically all these things are happening from a professional point of view. The main issue we are facing is regulatory aspects, because we live now in a sort of new transition period, which may take between 2 to 4 months till everything is clarified. It is not such a big issue for the ones holding a practice certificate in England, like majority of us, barristers, solicitors. But if you are a registered European lawyer, and there are many people on that position, the situation is critical because there has not been yet a clear agreement on what is going to be their position. They will be moved to foreign lawyers. What's going to happen with them? That's a big issue we are facing as a transnational practice. We are also registering an office in Cork, and I have seen 2 people from Cork joining. Hello. So we will see each other soon. And again, I mean, facing new issues there. I mean, it's an English-speaking country in the European Union. So that's going to be interesting, and a lot of data protection, immigration, and things that we will be discussing here.
Okay. In terms of firm operations, have you had to add or adjust any of your technology, especially when it comes to dealing with international clients? Peter, I think, yes. Fernando, do you mind telling us a little bit about what you've done?
I mean, basically, the main thing is, and probably Peter has much more than me to say about that. I mean, it's the data protection issues, I mean, related to clients. What do you do? I mean, legislation has not changed, isn't it, Peter? But what's the future?
Over to Peter.
Well, that's a good question. Yeah, I mean, having adopted and gone through the process of adopting GDPR, I mean, it's going to be interesting to see where we end up going. I mean, we have an extension at the moment of the transition period in relation to data, which is a good thing because we were facing this cliff edge along with everyone else at the end of 2020, and no real clarification on what UK organisations should do if they were going to be processing the data of EU citizens. Now that transition is extended for 4 months, so until the end of April. But the clock is very much ticking. We have to think, are we going to get an adequacy decision whereby data could freely flow from Europe to the UK on the proviso that your data protection regime is adequate, as the Commission terms it, or not? And I would urge everyone who's listening to us today and watching to think, use this 4 months we've got. You know, hope for the best, hope we get the adequacy decision, but regrettably, plan for the worst. Think about what happens if we have to rely on standard contractual clauses, binding corporate rules, codes of conduct. Make sure you have a safety net. You don't want to find yourself come the end of April when there may not be an adequacy decision. And I see any adequacy decision being against a political backdrop, a political context, as all of this has been. And regrettably, you know, that everything isn't great. We look this week in terms of a lot of the friction between the EU and the UK on trade. This could fall into part of that context. So hope for the best, plan for the worst. Make sure you aren't caught out at the end of April.
And what we've seen from the UK is that the ICO has deemed Europe to be an adequate place to store data, is my understanding, but it's the reverse that we're really worried about in this context.
Exactly. So as a UK-based organisation, if you are transmitting data overseas to the European Union, that's not a problem. Or anywhere else for that matter, we're saying yes, data can be sent, provided you are certainly free-flowing to the EU. As far as anywhere else is concerned, if you've got the right safeguards in place, that's fine. It's very much as you were. The problem is where we are potentially looking to access data stored in the European Union. And the important thing to bear in mind is that an awful lot of the tech that we use, everything from Amazon Web Services to Microsoft Office 365 to Apple to Facebook, all of the servers for these networks are EU-based, majority of them being located in Ireland, which is an EU member. And as things stand, if the UK got no adequacy decision, unless you have those safeguards in place of standard contractual clauses, binding corporate rules, or other mechanisms, if you've not got those in place, then technically you could lose access to that data, all of it, at the expiry of this transition period. So it is a major cause for concern. There's an awful lot of that needs to happen between now and the end of April to get that adequacy decision in place, because the consequences could be significant. The one benefit I see is that at least this is now data in isolation. It's not going to be confused with issues around containers going through Dover and shipments of widgets and things. We now just have this data at the end of April to think about data and get ourselves ready for it.
And as Clio's data protection officer registered with the Data Protection Authority in Ireland, I've been very much following this issue. So we're taking steps internally to protect our customers. But you're right, there's so much gray area that we're seeing right now. Sophie, dealing with a customer base that is international in scope, have you had to make any changes to your technology or processes when it comes to dealing with EU nationals?
I would say not tremendously in terms of internally how we have changed our technology. Obviously, very mindful of the points that Peter has raised, and my goodness, am I so pleased that I am not the partner in my firm that's responsible for dealing with GDPR, as that cliff edge was looming close. I was very relieved that it wasn't me. But certainly, just in terms of general Brexit impacts on technology and how that's impacted my practice, it has been a driver for change in a number of ways, as has COVID, of course, and some of that was touched on in the clip at the beginning. But just one example I would bring up is the Home Office's use of technology, and that's something that we as immigration practitioners have to engage with all the time, and indeed migrants, many of whom are employees of the organisations attending today. So because the UK suddenly faced the need to document potentially millions of EU nationals and their family members in the UK, it took a very different direction from the antiquated approach that we've all wrestled with the Home Office for many years, which was to bring in what seemed very clever new technology. And I can still recall the day that several immigration lawyers who've been practicing for a very long time sat around a phone on top of a passport, as if we were, early man seeing fire for the first time, and sort of went, as it extracted all the data out of the passport onto the phone app to populate an application rather than manually doing it. And so the need to process a vast number of people through the system has driven the Home Office to bring in what's very innovative for the Home Office, perhaps not for other sectors. And then building onto that, COVID has accelerated the pace of change to do that across the system. So we're seeing that that sort of technology exists for the use of EU nationals, but intended to be used more widely across the system. Small things like the use of electronic documents, electronic signatures, where previously originals were required. So in terms of how it's impacted us, it's more our interface with how others are using technology. And I think it's been a real positive and hopefully a continuing trend. So
continue on with that. Are you seeing a spike in immigration cases now that we've entered this period? You've mentioned before that we've had the unfortunate end to free movement. What does that mean? And how are you and your firm dealing with that? And what should other law firms know in terms of dealing with that?
Yes, it's a really good point. We are seeing a spike, but we have seen that trend from the referendum. I mean, as soon as the referendum happened, there was immediately an influx of queries, and we had a period of significant uncertainty where the government hadn't published what it intended to do. So it has been an ongoing path of sort of increased need from both business and individuals. What I'd say now that we have sort of two main areas, which is individual EU nationals and their family members who need to apply under the EU settlement scheme. The cut-off date for most people is the 30th of June of this year. So whilst there has been a historic rush, that's happening again as we get near to the June period, but also because EU migrants are now newly arriving EU migrants are part of our overall immigration system that applies to everybody. If a UK business needs to sponsor a foreign national worker, it does so under a sponsor licensing regime. And that means that a lot of employers who previously didn't need a sponsor license because any overseas national workers were EU now need them. So there's been a massive increase in employers deciding that they're going to apply for a sponsor license. And that, I think, is something that we're going to see continuing for a long time to come.
Are there any other practice areas? So we've mentioned employment now, needing services that didn't require them in the past. Are there any other practice areas, say family law, criminal, where we now have to bring in much more consideration about immigration law than we have in the past?
Yes, and I think in many ways there's been an overlap between those practice areas in the past. So, for example, in family law, we previously would and still do see cases where perhaps it's a situation of divorce and an individual whose status in the UK was dependent on their spouse now suddenly finds himself needing to have their own status, and that's an ongoing trend for all sorts of immigration reasons, but also in relation to splitting from an EU national. I would say other areas are things like criminal law practice, where certain offences would not have an impact on an EU national or family member because their protections under EU law were greater, whereas now that they're being treated under UK law, there are circumstances where certain offences could result in a basis for them being removed from the UK. I simplify somewhat, but it means that these issues have to be considered much more closely, and as the potential impacts when it's being decided how to progress a criminal defence case, for example.
So it's not just an export law firm or a data protection law firm that needs to be dealing with these, but every firm now needs to be considering immigration and its potential impact. I can think of several key areas, as we mentioned: family, criminal law, estate planning will probably be a key area as well, which I think leads us over to you, Fernando. What are some key changes to tax that firms and legal businesses should be aware of and planning towards? When we had a planning conversation about this, we talked about double taxation and VAT and how these firms need to start planning. What overall view can you give us about the changes in tax regime that we're now facing?
I think that the main thing we are seeing for UK residents, and this is very much linked to immigration, is a worry about, I mean, what are they going to do the more than 800,000 British citizens with a house in Spain, for instance? This is a question and query we are getting because we are the main chambers dealing with Spanish law matters in London. And we are inundated with questions like that. And that leads us to immigration, because the first thing is, okay, we can stay only 90 days over a 180 days period on the Schengen area. How are we handling that? We have a house. We were used to go there every weekend, not obviously during 2020. So this is an issue. And then this raised the issue of taxation. Taxation needs to be looked at from the double tax treaty, as we discussed it the other day. Double tax treaty hasn't changed. I mean, many other things has changed, but double tax treaty still in place between the UK and Spain, and the UK and all the other countries in the European Union. So that makes the tax planning basically subject to very little changes. I mean, in terms of income tax, capital gain tax, and the same is applicable to corporation tax, apart from 2 or 3 particular areas which are regulated by European law and we may not benefit, like merge and acquisitions directive and things like that. And in the transfer pricing area, we may find also some issues and also permanent establishment, but those are more corporate. From a private client point of view and estate planning point of view, again, inheritance tax is not covered by the double tax treaty. So in that particular one, we will need to take a purely UK and Spanish bilateral approach, applying unilateral tax relief when needed. And this brings us to another topic, which is execution, probate. What's going to happen? Because we are now outside the European Union territory. So how are going to be executed the probate provisions on a will? I mean, how this is going to be working? So those are matters that we are going to be seeing developing in the next few months. And that is affecting particularly UK clients with interest in the European Union. So we are dealing with that quite a lot.
One of the things that was very interesting to me is you keep mentioning bilateral treaties, and we normally think of the relationship right now between the UK and the EU as two unions, right? Yes. But that's not really the case when it comes to taxation. Yeah,
it not, and we may find also in other areas that type of bilateral agreements softer or harder. For instance, I mean, in the profession, I mean, we are talking among lawyers. So how our profession is going to be regulated? We cannot wait for the guys in Brussels to sit with the people in London and decide what's going to happen in the whole European Union. So the particular states and countries are moving forward and agreeing with the Law Society and the Bar Council how this is going to be working. So there are bilateral agreements happening between institutions too. So not only tax. I mean, tax has been always the domain of the sovereignty of the states, and it has been excluded from the European Union. Direct tax, indirect tax is a different matter. I mean, VAT and customs obviously will be working differently. But in terms of direct taxation, we have bilateral agreements.
So what's an immediate change that we need to be prepared for, and what should firms be looking for in the future, and where can they kind of monitor some of these changes?
So basically, I mean, one of the main changes that we are going to be having, and apologies, the Amazon guy is calling, these things happen in direct. So do you mind if someone else covered this while I come back? I mean, just 1 second.
Yeah, let's jump over to Peter.
If I miss that, there is an issue.
Yeah, we do have a question, Peter, from another Peter who's asking, who makes the adequacy decision that is this looming deadline for data storage? Peter, do you mind addressing that? And then I'd like to jump into some of your practice area.
More than happy to comment. So yeah, I mean, the interesting thing with adequacy, I mean, how long have you got? So adequacy is a decision made by the European Commission, whereby it sort of makes a slide rule to a country's privacy and security laws and says, we think that your data protection regime is adequate in comparison to the laws in the European Union. We will allow the personal data of EU citizens to pass to your country and to be processed in that country. So it's a decision made by the EU, but they sort of apply some very strict tests. It took New Zealand 6 years to get an adequacy decision. It was rushed through for Japan in about 6 months when it came to the Japan free trade deal. And Canada was kind of in the background during their sort of labyrinthine 6 or 7 year negotiation.
During the CETA, yeah.
But, you know, this isn't the work of a moment. Interestingly, you don't have to go through all these tests if you're within the EU. You just stop their regulations, you take the derogations, that's it. If anything, it's almost like, yes, you have to pass through the eye of the needle when you're outside. Interestingly, I think arguably there are several EU countries, which I know I won't name, but I think they will struggle to get an adequacy decision, given some of the measures that are in place in those countries. So the UK might be in difficulties getting an adequacy decision because of some of the established practices we have around things like bulk data surveillance, so the granting of warrants by security services so they can look at bulk text messages, social media messaging, bulletin, all this sort of stuff. Because we have those powers and it's well used and well established by our security services, that might mean that if the EU is so minded, it may find an excuse not to grant an adequacy decision by dint of, well, you have these bulk security practices that are similar to the practices in the US, which have precluded the US from ever getting an adequacy decision. By the same token, there are also recent decisions of the European Court of Justice that I've looked at and I thought, if you wanted to find a reason not to grant an adequacy decision, there's plenty in terms of written decisions from the European Court that would give more than enough cover to the European Commission to not grant the adequacy decision if it was so minded. But I know that, Joshua, when we've talked about this in the past, you were like, oh, I think you were hoping there would be an adequacy decision, and I'm sorry to be the party pooper by sort of adding the reasons why there might not be.
Well, that very much does seem like the worst case scenario, given the guidance from the European Data Protection Board on evaluating different jurisdictions. I do see exactly where the UK may struggle with this. What should firms be doing to prepare for that worst case scenario? You talked, for example, about standard contractual clauses. We know that they're being currently reviewed and there are draft updates for that. How do they navigate this period of a data extension, a looming adequacy decision, and an uncertainty around what type of kind of protection measures they can offer on behalf of EU residents?
Yeah, so the standard contractual clauses can be used in any sort of third-party data sharing agreement. So important, I think, to start off for any organization, just to do a quick stock take in terms of where is your data stored. It's not just the obvious things like, oh, where is our data for our case management system or our email or our operating system if you're using Office 365. It's deeper than that. I mean, think about, for example, your phone contract. Where are your voicemail records being stored? Even down to things like CCTV. Very often that is now backed up and stored in the cloud forever on someone's server somewhere. We've got a 4-month period to look at this, and I'd say, start using it now, because I recall the conversations that I have had with compliance officers in law firms where they've said, we have thousands of contracts we have to review. One city firm I spoke to 2 years ago, the compliance officer said, yeah, I had to review 3,000 contracts as part of my GDPR due diligence to make sure they were up to date. And it's going to be a similar in-depth exercise here, regrettably, to make sure that all of those agreements have the right standard contractual clauses. And just for the avoidance of doubt, that's the standard contractual clauses which are in effect now. You are quite right, Joshua. They've consulted on new ones where they will not come in at the most until probably the end of this year, and there will then be at least a 12-month window for organisations to adopt them. So we have to sort of think we are where we are. We use what we've got. Regrettably, you might have to replace them in a few years, but that's, as I say, part of this ongoing compliance obligations that we will now have in so many different sectors as this relationship with the EU continues to evolve.
And jumping back to Fernando, is Amazon all clear? Excellent. You've chosen to open an Ireland office. Do you mind telling me a little bit more about why you've chosen to add another connection to the EU in addition to your offices in Spain and London, and what was the process behind that?
Yeah, so basically the point came because we were asked by our US clients to consider Ireland as a place for business in Europe because they wanted to continue working in English. So London has been a hub, and very important hub in the European Union. They wanted to have the facilities to operate in the European Union from an English-speaking jurisdiction bona fide, especially because we work quite a lot with intellectual property. And Ireland offers very good advantages also on that. So we use the occasion to move all our administrative, clerking, marketing, communication, PR services to Ireland. So we are providing now from Ireland our services to Spain and the UK, including Clio, that you may know. I mean, we are using Clio for Spain and the UK under the Irish account. And then, Peter, we are doing exchange contracts for data protection and all that stuff, which we didn't do before. I mean, we were much more comfortable in that environment. So basically, those changes are happening now. I'm basing in Ireland all our admin services for the two firms in England and Spain.
It's very interesting. And Sophie, one of the things that you mentioned is that there are opportunities for a greater talent pool here. We see Fernando taking advantage of expertise in Ireland. You're seeing that firms within the United Kingdom may have access to a greater talent pool than ever. How has that come about?
Yeah, that's right. And although obviously there's a concern around loss of ease of access to the EU talent pool, it's still there, it just has to be accessed in a slightly different way. And principally that's going to be for new arrivals through the sponsored worker route, the skilled worker route. But the criteria have been changed to the skilled worker route, which was previously a scheme called Tier 2 that many of the delegates today will have heard of. Really widening and somewhat lowering the bar of that route. So whereas, for example, before, a role had to be at skill level 6, which is sort of degree level, it's now at skill level 3. So it expands access to the types of roles that would be from an A-level student sort of above. So that's a much wider group internationally. So not just EU nationals, but non-EU nationals, or the types of roles that could be filled by those nationals. We also have things like the resident labour market test that used to exist, having to demonstrate that you could not find a worker in the UK, a resident worker in the UK, to perform the role. For the most part, that is not required now. So it does mean that many businesses will find that they are able to sponsor an overseas national worker in a role that the previous scheme didn't allow them to do. And I think quite a number of businesses are beginning to become aware of that and see it as potential scope for opportunity to access more talent.
And it's not just limited to EU nationals then. This is a global talent pool.
Exactly. So our previous Tier 2 route, which is now called the skilled worker route, was the route for non-EU nationals, and now it's the route for non-EU nationals and EU nationals alike. They all have to meet ostensibly the same criteria. Yep. So looking at it in the legal context of legal firms, a paralegal previously could not be sponsored. A paralegal now could be sponsored under this route. And so whether that's law businesses themselves or their clients, they have the opportunity to sponsor a much wider group of individuals.
We can bring the best of the legal minds around the world to Britain and have them practice on behalf of the British. Are we going to see any issues with UK legal professionals going to the continent? So, for example, Fernando's mentioned that we're very much going to be looking at almost bilateral law society agreements for recognition of professional qualifications. Is there anything that law firms should be doing now to prepare for business abroad?
I mean, that certainly is one of the aspects of concern. And for many of our clients, we have always, my area of expertise is UK immigration. And so one of the key concerns is with free movement gone, that the flip side of the coin is when a UK business needs to send its staff to Europe, how will it do that? The potential to have to be looking at the domestic immigration rules in a number of different countries is a big concern. And coming back to the point of perhaps opportunity for practices, I'm aware of many immigration practices that are actually looking at expanding their offering to their clients so that they're not just advising on UK immigration, but also setting up in the other jurisdictions. And it's interesting, Fernando, talking about Ireland. I think that's been a very popular location for many reasons, and for many clients, they've moved their operations or expanded operations into Ireland for exactly the reasons that Fernando was outlining, and therefore they may be needing to bring talent into that jurisdiction and needing to meet requirements there. So it definitely raises that additional complexity when you're dealing with workforce management of having to engage with a wider range of different jurisdictions and their laws. It adds absolutely a complexity to workforce management.
And complexity, while a detriment to many, is actually an opportunity to our profession in many cases. And I do view this as an opportunity to provide great counsel, to provide great guidance, because people are definitely clamoring for it right now. So I think we're nearing the end of our panel period. I would like to give everyone an opportunity to talk about two things. One, what are some upcoming dates within your particular area of expertise that our audience should be aware of? We've mentioned several already, but for Sophie, I'm wondering what is the EU resident cutoff and application process timelines that we should be mindful of with all of our clients right now. Fernando, we're going to be looking at a different tax filing periods and what are some upcoming ones that we may need to keep in mind. And of course, Peter, while we have the adequacy decision, there's also an extension to the extension that we might need to be considering. So, and then what other key area of this free trade agreement are you focusing on in addition to those dates? So Sophie, if you could kick us off with immigration dates.
I'm going to try and cram in quite a few ideas
so
in
many,
a short space of time. I've already mentioned the key date, of course, which is the 30th of June 2021. That is the application deadline for most people, but not everybody. There's not time to talk about those who don't fall into that, but there are exceptions, so it's important to be alive to that. But for the vast majority of people who arrived before the end of the transition, they need to get their applications in by the 30th of June, and there are regulations that protect their status after that, whilst their application is pending, if it hasn't been decided, as long as they were exercising a treaty right on the 31st of December 2020. And some people may have been here, but not have been exercising a treaty right. So some notes of caution to sound there. I think the other area that I would flag around sort of timelines is that individuals must start their sort of continuous period from a date that is no later than the 31st of December 2020. And from whatever date it may be, could be earlier than that, but no later than that, they mustn't have broken that continuity by things like absence. And this has become a real issue because of COVID. So if, generally speaking, if someone has been absent for the UK for more than 6 months in a year, they've broken their continuity and they will cease to be protected by the withdrawal agreement with certain exceptions. So we have quite a lot of workers who are working from home and they've opted to do that with the agreement of their employer outside the UK, and they may be breaking continuity, and the latest that you can restart your period for continuity is December. So it's really important that people aren't just thinking about the deadline for making an application, but they're also thinking about the deadline for when am I going to hit absence that's actually going to take me outside the protection of the withdrawal agreement. So I think that's my sort of word of warning that employers and individuals need to be thinking about, where they could inadvertently lose their rights through absence with the ongoing COVID difficulties in particular.
So much to navigate. Thank you. And Fernando, are there any upcoming deadlines or dates that we need to be aware of, especially when it comes to taxation?
Yeah, I mean, I think planning is the key here, and reviewing our existing structure is important. I mean, if you are operating with a subsidiary or permanent establishment or branch in the European Union, this is a good time to look at what we are doing, not only from a direct tax point of view, but looking at the future of customs and regulations, and obviously VAT. So that's one area. Another area I think requires particular focus from a commercial point of view is arbitration and mediation, and that's not only because of the European Union or the Brexit agreement, is because of the COVID situation and the difficulties to really move things forward in tribunals in the European Union and also in England. So mediation and arbitration is something that we should consider, I mean, as an alternative dispute resolution method, and is something we are seeing an increased interest on that. And then from a family point of view, I mean, divorce, custody, all the different issues related to that, I mean, it's changing drastically and dramatically and needs to be taken into account. And that will link with execution of court decisions and recognition of court decisions in the UK and the EU. So there are a substantial number of private or classic, international private law type of issues, conflict of law type of issues that needs to be looked at from now on when operating in the European Union or with the European Union.
So much more to handle. Wow. I'm sure we've got the right audience to handle it, but it's very much to keep in mind. And Peter, last but not least, what are some future looking concerns that we should be aware of? We've mentioned, of course, our 4-month adequacy grace period. There's a potential extension to that. How will that operate?
Indeed, there is the potential for an extension, but sometimes as well, we've already seen the focus of the deadline and how that's been able to concentrate minds. So I'd like to think this will be resolved one way or the other within those 4 months, but it may not. It could be that we end up seeing another 4 months. But I think at the moment, the only point of certainty is saying, well, we have that 4 months. Let's see where we are at the end of that. We've already seen that I think the land has already shifted since end of December when this agreement was struck, and then where we are now at the end of January. So frankly, who knows where we'll be by the time we get to April. But I think it's also worth thinking about with this agreement as a whole, that there are substantial parts of it that are up for review in 4 years' time, so 2024. So that comes back to my opening comments that don't just think that this thing is now set in stone forevermore. It will continue to evolve, and we'll end up looking to find, what might be changed, what might be reviewed, what might be added to come 2024. And then in the meantime, there will be that memorandum of understanding, which it's also a treaty. It's not sort of something necessarily subject to active negotiations. It's just something that Europe is looking to have with the UK in certain sectors in the coming months from a regulatory perspective. We have what and how different regulations will apply.
All right. So we very much built a foundation with this free trade agreement, but there's a lot more building to go is what I'm hearing. And a lot of guidance required in order to get both law firms and our clients into this new environment. And with that, I want to thank our panelists for providing this expertise. And I'd like to open it up now to the audience to ask questions and to see if there's any area that you want to talk about in terms of technology, taxation, immigration, managing a practice in this new multinational environment that we find ourselves in. And if not, I do want to thank everyone for attending today. Geraldine, do we have any questions on the line?
I think you've covered most of them, Joshua, but I'm just going to give folks, even if you want to raise a hand, so we know that you have a question that you want to put in. If not, we can close out. Just give folks a moment.
Yeah, we went just a hair over into question time, so.
No worries. No, I think we're all good. A lot to chew on, as they say. And I think that's what people are saying now. We are recording, so we will get you the recording so you can go back over what Fernando, Peter, Sophie and Joshua have discussed. That will be going out in the next 24 hours or so. And stay tuned for more events like this, more discussions like this. Thank you to all of our panelists and to our moderator, Joshua. Stay safe and stay well.
Thank you, everyone.
Thank you.
Thank you.